p.m. Ms. Cruz, this looks like it is, let's see. Well, no, I'm sorry. It's your motion. Ms.
Yes, it is.
Jernigan? Okay, please proceed.
I'm sorry, sir. Did you say Miss Jurgen, or were you speaking
Well,
to me?
I believe it's, forgive me, we have a motion regarding custody from you, Ms. Cruz, correct?
Yes, it is.
Okay, so this is your motion, and we have a response from her. I'm looking at the green card, and for some odd reason, somebody put Ms. Jernigan's name as the filing party, and I'm like, that's not what I read. So it's the green card that everybody fills out is the card that tells the court to pull the file, to
Oh,
send it to
okay.
their judicial official. So sometimes and that's what's right on top. So sometimes those aren't filled out exactly correctly, but I'm looking at that going, wait, that's not what I read. So Ms. Cruz, this is your motion, which is what I thought it was, despite what the top piece of paper says. So you may proceed on your motion, ma'am.
Okay. I am filing this motion for custody of Hamza. We have children together. This is motion has been held by me. I was going to file many years ago. I've given him many opportunities to, be a better parent. This is not what I wanted. This came about because my children on the 27th, after I picked them up from their father's house, my youngest Solemn had said that he was upset because of the way his father had behaved, and he felt like he was in danger when they were driving for a road rage incident. So my concern is that there was a weapon that was brandished by the passenger, and my children were on the passenger side of the vehicle in the front and back seat. I've witnessed, yes.
Is there a police report to this?
Not on my side. I'm not sure if he had.
Ms. Jernigan, was there a police report that was filed on this?
I do not believe so. My client tried to call 911.
Yeah, I called.
Okay, there's no police report. That was the answer to the question. Okay.
So in turn, the children asked me not to go to their father's. They didn't want to go back to his home, and they love him, but they are nervous. They feel manipulated. They feel sometimes, not always, they are in danger. It's very
in
abrupt.
What way are they in danger?
He has taken the kids to some sketchy places, friends of his, business acquaintances throughout the years. I've been witness to that. I have been involved in a lot of situations that I would like to bring to the forefront.
You indicate that Child Protective Services was involved at one point. When was that?
I did. I did call Child Protective Services the day after. I think it was on the 28th or 29th of July.
And
somewhere in there.
What was the outcome?
I was told she went and her name is Hannah. She went from CPS and came to first went to his home.
Right.
I was told, and whatever investigation she had I was not privy to. She just said she was when she came to my home with the boys. She spoke with both children separately. She also, my mother was here. My mother spoke with her. At that time as well, Mr. El-Sheikh had sent the Kent County Sheriff's 2 vehicles with himself over to my residence because he wanted his children.
Because it was his parenting time? Or why would he have done that?
Yes, we have unestablished parenting time because of my work schedule. And it had not, he stated on the motion that we had been parenting. He had them from Thursday, 4 p.m. And it had not, he stated on the motion that we had been parenting. He had them from Thursday, 4 p.m. through Monday mornings.
Right.
This is because I work Thursdays and Friday nights for 1 year at Dollar General. So there's not a three-year thing. We have always been trying to get the correct visitation custody for the kids. The boys have expressed that, especially my youngest, they're not happy with the situation, with the living arrangements and things like that. So
did you read the response by chance?
I did.
Okay, there is no change of circumstance for custody in this. You cannot meet the legal threshold for any change of custody. The problem is there is no outlined parenting time for either party, correct?
Yes.
Ms. Jernigan?
Correct.
Yeah, they just have the agreement that says 50-50, which I attached, and they verbally agreed and have done that.
Right, right, or close to it. But it sounds like we need to get an actual specific parenting time.
I agree.
Yes, please.
Yeah, the fees have been suspended in this, so I will send it to the front of the court for parenting time.
May I speak one more time about the parenting time? Is that all right?
Okay.
I requested a 3-2-2-3 custody split with him so I could have alternating weekends.
Right.
He said, yes, this was in the spring. Then he only had to let the kids come over on one weekend. Then the other times he said no. He refused. We are always walking on eggshells.
That's why I'm sending it
Yes.
for a specific parenting times. There are no more disagreements.
Wonderful.
Your Honor, can we
Yes.
also, I'm sorry, can we also maybe, we can send it to Brenda the court, but I'd be more than happy to try to mediate with the parties.
From what I've read, I'm not sure that's going to help. I
Okay.
think we need a recommendation here.
Okay.
So, I will send it to the front of the court for parenting time and child support. The fees have been waived in this case. And as to the other issues that were brought up in the motion, that seems to be an adult son in Egypt that is attempting to blackmail somebody. That
Yes.
is not relevant to the custody.
Thank you.
So, but it does give some relevance as to why the relationship between these two parties are strained.
Yeah, and Your Honor, this is like a weird, I have another file where I've had this blackmail happen. So I don't know if there's been this is awful, but so I wasn't trying to.
In Michigan, revenge porn is illegal.
Yeah, I know.
So however the son got those pictures, however they came about, that would be between the mother and him, and
Okay.
the Hague Convention's involved since we have international countries involved. So I don't know how that would work, but that's not relevant to the two parties here, although it might give some animus to why we've got motions being filed all of a sudden. But at this point in time, what really needs to happen is a set schedule specific to these parties so that the kids know when they're going. I'm not holding against him a road rage incident where somebody pulled a gun on them. According to him, he was driving correctly, and that's what pissed off the other party. Is there any way that no, because I'm not getting into your issue and I'm not getting into that issue. I'm just saying, for the record, the court's not going to change custody over something like that.
Your Honor, what about the school issue? It's my understanding that the minor child, Salem, was taken from one school to another.
Oh, yeah. As to the school, I'm sorry. The school must stay where the school was at last year. You don't get to change schools.
Yes, he is enrolled in Meadowridge.
Okay, so he's okay.
Yeah. If you do want to change the school in the future for either child, you have to file the appropriate motion for change of school, and then the court must have a hearing on it. Until such time as the hearing can be held, the child remains in the school where they were at.
Yes.
And if you are now out of district, I will get you an order to keep them in that school until the court can make a determination.
Good.
Sorry. Would the court? Is there any way the court would order an interim parenting time schedule pending the front of the court recommendation?
They should be following what they were doing in the past, and it is listed as 50-50. So you guys have joint physical custody. How you've been working it out in the past. Again, she just said that part of the reason is because of her weird work schedule.
Sure. So I just asked
if the parties agree to a 2-2-3-3, that's fine. I've had children that hate that.
All right.
Okay.
It works for some people. Great. If it works for you, I don't want to step in, but I will tell you that when it goes bad, which is the only ones I ever see, I only see things when they're not going well. The kids are telling me, please stop this because I can't, I'm tired of moving houses every couple of days. They get exhausted. So if you're going to, normally draconianly, I could look at you and go, I'm going to go week on, week off. Because that's precisely what I'm going to do. You guys have 50-50 custody. If you guys agree to something like that, put it in writing, and that can cancel the front of the court meeting. Okay.
Right. Tina, would it be all right for me to reach out to you to see if we can work out a schedule?
Please, I would ask that you parties do that.
Okay.
Because I'd rather you guys control your lives than the courts. So that's why I gave some guidance as to I would probably order a week on, week off, but the front of the court can work with you on specific times. Because ordering something right now, I don't know what his work schedule is. I don't know what her work schedule is. So you want me to order something, and then the next thing I know, I've ordered it onto her. I've given her the kids on her work schedule. She ain't going to see them. They're going to be in daycare. So.
Well, my client's disabled and it's not working. So
there's a reason I brought up her work schedule, not his.
Okay.
All right. So the front of the court will be contacting you shortly. Yes.
Sir, is there I'm just a little frustrated. The process for never. I'm having a problem with are we going to do mediation? Is that what that is?
No, what I'm saying is if you guys mediation is not what I'm sending you to the front. I'm sending you to the front of the court because it sounds like the two of you are at an impasse on trying to agree to something. That does not preclude you from agreeing to something. I'm opening the door to say if you guys want to talk about this and agree to something outside of front of the court, that's great. But once the front of the court gets a hold of it, they're going to make a recommendation.
Correct. Okay.
All right.
So,
And it may or
yeah.
may not be to either party's liking. I can tell
Okay.
you, generally tell you it's to neither party's liking.
Of course. So, you know,
Right. Which is
um,
why I'm opening the door to say you guys can control this or the court will.
Okay.
All righty. Good luck to both of you. All right. Have a good morning.
Thank you, Your Honor.
All right. Next. All right. Ms. Farr,
Farr
welcome.
versus
Hello.
I guess that answered my first question on this, was whether you got the motion or not.
Yes.
So, question answered. Mr. McKnight, did you connect?
Yes, sir.
All righty. Okay, we are here in the matter of Farr versus McKnight. Sir, I believe this is your motion. You may proceed to add to it what you wish.
At the time now?
Yeah. Yeah.
Okay, so I feel like my rights was broken. My voice was never heard. I wasn't given the opportunity to be a father and to show that I was being responsible and my son was safe.
Okay.
Um,
When was the last time you saw your son?
the morning that the incident happened.
And when was that?
Uh, I can't remember the exact day. The day of the incident where they took my son away from my home. I
Okay.
haven't I haven't spoken to Juju since then.
Can you give me an approximate time?
Yes, sir.
Spring, summer, year?
Oh no, this is recent. I'm sorry.
That's why I'm asking. And when was this? You said
July 18th to
July 18th.
2024.
Yeah,
Okay.
thank you.
All righty. So, and so you've just recently had him for the summer, correct? How long did you have
Yes,
him?
sir. I have him for about 3 weeks.
Okay. You get a period of 4 consecutive weeks every summer. Did he have 4 or 3, Miss Farr?
He had 3 weeks. I mean,
Okay.
he was going to have the 4 weeks. We had it lined up for 4 weeks.
What happened?
Are you asking me or him?
I'm at this point, I'm not sure who to ask.
So
Because Mr. McKnight says that the child was taken by whom?
The Grand Rapids Police Department.
And why was that?
I was in Florida at the time.
Well, that's where you live now, correct?
Yes, sir. Yep.
Okay.
So
Mr. McKnight, why were the police at your home?
so so apparently my son, he sent a video and said that he was home alone.
Okay.
Miss Farr called the police department and said that our son was at home alone and I
Okay.
don't know, frantically or whatever, and they came out.
So they came out, and why did they remove him?
They removed him because Miss Farr guided him to come outside to the police and said that he was home alone. I had my roommate here.
Was she there at the time?
She was in Florida, sir.
Okay, because the police are not going to take the direction of a citizen. They're going to
Yeah.
they're going to do a wellness check. Now the
So with the
question would
wellness
be,
check,
what did the police find?
They
that
never
they were
came
going to-
inside the home.
Okay,
They never came inside the home. My son came outside. He said
okay,
that he was home alone. My son came
Okay.
outside and they took him.
all right. So I'm not sure Miss Farr had anything to do with that. And
So-
what happened afterwards?
Miss Farr gave the police the wrong number to contact the father, which is me.
Well, wait a minute. You're saying that you had a roommate there. Why wouldn't that roommate have come out and seen what was
So-
going on and
so-
give them
so
the
my-
number?
Yes, sir. So my roommate was asleep.
Oh,
I was only
okay.
gone apparently for like maybe 2 hours, and it's a gap. It's like a 49-minute gap between my
So
roommate waking up and the police department taking my son.
Okay, so all right. And what happened afterwards? Did the police return the child to you, or did the police return the child to the mother?
So the police took my son to the older brother, which is Tyrone Bowman, her
Okay.
oldest son.
Okay.
I went down to the police department as soon as okay, so let me start over. When I got a call that my door was open, from my roommate. So he wakes up, find out that the door is wide open. I said, absolutely not. I did not leave my door open.
Have you gotten a police report over the incident?
Yes. Yes, I
Okay.
do.
All right. And ma'am, when did you pick the child up?
I flew in on July 20, 26th. So I had him as of July 20. Sorry,
All right.
making sure of
Yeah.
that. Yep, July 26th is when I received him.
Okay. And he was with your older son up until that time?
No,
Where
no.
was he?
They actually, Terrell McKnight and Janice Schnitker, who is my biological mother that I haven't spoken to in over a year, showed up at my son's house with the Kentwood police.
Okay. So they got him
And
back?
no, the Kentwood, well, Terrell gave Janice Schnitker my son through the Kentwood police.
Whoa.
And then when Janice Schicker had my son, she ended up smashing my son's phone that I sent with him. My son, I guess I would say, emotionally broke at her home. She called my sister. So then my son ends up in Berry County, goes from Grand Rapids to Kentwood to Berry County, all within 4 hours. Which my sister did say she wasn't trying to be involved in whatever Terrell McKnight and I had, she's trying to do what she needed to do. And so she gave Mr. McKnight the opportunity to go and pick up Terrell Jr. And he told her that he wasn't driving out there due to law enforcement, and him being black, he would be shot. So he had an opportunity to pick up Junior. That was a statement he made. I had
All right.
called.
Bottom line, you got the child back. This was done by police intervention. Mr. McKnight, what do you want me to do? Because
Look at her. Look
it's
at her
not her that-
smiling. Sir, please, can I listen? Can you talk? Can I talk for 1 second? That statement she just made was absolutely absurd. I went down to so after I went to the Grand Rapids Police Department, the police officer gave me Tyrone's number and address. Said, this is where your son is.
Okay.
I apologize for not calling you. The mom gave us the wrong number to contact you. That's where it all started. Why would you give the wrong number to contact me? And
I gave the correct phone number. I
It's in
do
the police
apologize.
report. It's in the police report,
Whether
Danny.
they
Yeah.
wrote it down
Hold it,
correctly or not, I'm
hold
in
it, guys.
Florida.
Hold it, guys. I don't have a copy of the police report. Matter of fact, a lot of this isn't in your motion, sir. I mean, you got 3 out of the you got 3 out of the 4 weeks. The 4th week kind of fell apart because of issues that are out of both of your control at this point. The police were called. The police did an intervention. The police took the child and placed the child where they believed the child was safe. Wrong number or right number. Bottom line, the child was able to exit a house without anybody supervising him, and the house was left open. So obviously there may have been somebody in the house, but the kid was alone. So the police did what they needed to do. So
Okay. So granted, so once I was able to get my son back, the police said my son was out of control. Yeah, he was crying hysterically a little bit, but at the same time, he was guiding him to go outside and all of this. He coaches him, sir.
Who
Well,
did?
your problem is then with the police, not with your ex.
So hear me out. She was on the phone with the police. She was
I
like,
didn't
my
coach
son
anybody.
doesn't. Can I talk? My son doesn't want to go with her and all that. I had the police didn't even look at my court order.
Yeah, they did. I
didn't even have-
emailed
they didn't
parenting
have
time to
audacity.
the Grand
All
Rapids
righty,
Can I talk?
guys. No, you're done. This motion is denied at this point. There's nothing that the court can do except to say that in the future, follow the court order. I'm not denying your future parenting time. I'm just
She took
saying.
my son. They took my son and passed him off, though. I haven't even got an opportunity to really spend the rest of my parenting time with him. She took it.
At this point, the police took it. So no, there's a third-party intervention here that was not her. It was
Sir.
between. No, we're done. The motion is denied. Have a good morning.
Thank you, sir.
None of that was in that. None of that was mentioned. It's like, say what?
That's not helpful.
No.
All right, I need to identify some phone numbers.
Okay. We get ones like that don't have anything in there that they really want to talk about. Then I've got the other one that I finally finished reading last night that has over 500 pages to it.
Yeah. I'm just going to bring the other phone in. This one's
Okay.
taking forever to connect.
Okay.
But usually when I do that, they both connect at the same time.
Of course they do. I have a motion to transfer the case to Ingham County. I believe that's where you live, Miss Fagan, correct?
Yes,
And that's where you've lived for how long?
2.5 years.
Mr. Bell, you live in Nuevo County, correct?
No, I live in Grand Rapids, Kent County, Your Honor.
Oh, that's why this motion is going to be easy. As long as one of you still lives in Kent County, we don't transfer it. You both have to be living out of county. I had your last address allegedly is in Nuevo.
No, I never lived
Both of
in
you
that.
have both of you have confidential addresses. So double check your address and make sure your address is correct with the front of the court in writing. Okay.
Okay.
But I thought it was going to be granted because neither one of you lived in the county, but as long as you live in Grand Rapids, I just needed confirmation that both of you lived out. Yes, Ms. Fagan.
Judge, I went ahead and did the motion because before I moved, the lady at the front desk told me that wherever the kids live, that's where the case will go. So that's why
Potentially, but if we still have one of the parties that lives in the county where the case was incepted, the case stays in the county of inception. We don't send these off easily. We only send them off when we have no connections any longer. As long as we maintain a connection, we continue the connection.
Okay.
All righty.
Yep. Thank you, Your Honor.
All righty. If you find any other information or if he moves out of the county, Ms. Fagan, then you can then you can reapply this motion. Because again, it would be easily granted if both of you are out of the county, but if one of you still remains in the county, we don't let it go.
Okay.
Other counties don't appreciate when we slough off work to them.
Okay.
Basically. So when it becomes obvious, like both of you don't live here anymore, great. But if one of you lives here, no. All righty. Have a good morning.
All righty.
Thank you for your patience.
Have a
Take
good
care.
day.
Have a good day too.
¿Quién
All
más
right.
no quiere
Now,
decir?
Como le escribí al juez de la razón que estoy pidiendo, pero antes de eso estuve también fuera del trabajo porque tuve una
all right. You might want to slow down. Let's let the translator catch up.
Espera un momento para que el intérprete pueda interpretar. Yes, I wrote you and the reason I'm asking for a change in the support payments is I had a big change in my life. I had medical issues. I had to go to the ER, and even before that, I was out of work. Adelante, puedes seguir.
Yeah. Ms. Jimenez, any questions? Anything that you might know?
Your Honor, we are aware he was in the ER because there was like a fight that he was involved in. However, we are in agreement that the case be sent to friend of the court for recalculation of support.
I think there is a change of circumstance that I can't overcome, regardless of why he was in the ER. Also, that he had another illness as well on top of that also detracted from his ability to work.
Yeah, the other reason is, I'm sorry.
Oh no, that's okay. Go ahead.
Adelante.
The other reason that
Ms. Jimenez, you are completely broken up.
the court is because he is currently getting graded.
He's currently getting
Can you
what?
hear me?
No, it was.
Credit?
I think you need to repeat what you just said. I don't think that needs translation, Mr. Boffel.
He is currently getting credit for another child that just turned 18 and graduated,
Well,
and he's doing 0 overnights.
Yeah, that's another change of circumstance that allows for a review of child support.
Y que
All I need is one change of circumstance. Sounds like we have 3 or 4 here. Mr. Guadardo Diaz, any job prospects in the future?
No, que agarraron otra persona.
Yeah,
Sigo aplicando.
I've applied for 6 different jobs and I got 2 calls for interviews, but then both I got an email saying that they chose somebody else, but I'll keep trying to find a job.
Please do, and I will send this to the front of the court for a child support review.
Por favor, haga
Your Honor,
eso.
before we leave, if I just want to
Ms. Sumner, can you hear me?
Yes, I can.
All right, Mr. Tipke, can you hear me?
Yes, I can.
All right, let's go on the record in the matter of Tipke versus. Ma'am, this is your motion. What do you have to add to it?
Really, I just want to say that I pay $90 a week in child support, and she still doesn't have her own bedroom. I haven't seen her all summer because he's got some idea that he won't call and make a report on or anything. And I'm really sick of going to that house and getting into arguments, especially with his mother, who really shouldn't have anything to do with it, and in front of her.
All right, Mr. Tipke, what's going on?
Yeah, back on 5/1/24, my daughter just came back from her mom's house.
Right.
She was taking a shower and
and you caught her in a position in which every young child would hate to be caught.
Yes, but at her age, she shouldn't even know about any of that. And
that is where you are incorrect.
And it comes down to a lack of parental responsibilities and neglect.
This happened on your time. Did CPS?
Yes,
Sounds like
yes.
everybody investigated this and they did not substantiate anything, correct?
If you go through everything that's happened, you'd have the same conclusion I do that
No,
something
no, I wouldn't.
You haven't heard none of the evidence. You don't know anything that's happened. If you'd let me state the facts, everything
Well,
that's happened.
that's the fact that matters is Child Protective Services investigated and did not
No, they
substantiate.
did not.
That's because you didn't call, Jack.
I went to the hospital. There should have been a mandated reporter that reported. I went to Network 180.
Okay.
Both doctors said that everything seemed 100% normal. That is a fact. So if you thought there was something beyond that, you should have done what the doctor suggested.
Hold on, guys. There is no legal reason for her to have parenting time withheld, Mr. Tipke. Whatever your beliefs are, there's nothing legally.
She has admitted to me that she sleeps in Nick's bed with her while Cherie's at work, and she ain't even
That never
there.
happens.
Cherie has admitted that Jamie has been found naked in her closet with her clothes off when she came home from work.
Okay, and why has none of this been reported?
Her boyfriend Nick, that has just got out of prison last year, that Cherie won't tell me his last name, why he was in prison.
Well, I'm going to let me ask that now, Miss Sumner. Why was he in prison?
He did have a third-degree incapacitated adult person charge from a threesome that he and his wife were involved in after the bar. But his parole is done. It was not with a child. He never even met her until after his parole was done. He wasn't allowed to be around children then. He is now. Get off the couch.
Really? So maybe Mr. Tipke does have some justifiable reasons as to why.
Then maybe he should have called the police.
There's more to this too. Can I keep going?
Well, none of this is before me is the problem. All that was, I got no response from you.
The night before this incident happened, Nick went to jail for hitting Cherie for domestic violence.
Okay. So we've got domestic violence issues in her home as well.
Yes.
There's domestic violence issues in your home too, because the whole reason I can't get a lawyer from legal aid is because they represented you in a domestic violence case.
All right.
It was not at my house.
So what I'm going to do is send this for a parenting time review to the front of the court. And Mr. Tipke, I suggest you get all that evidence together. Ms. Sumner, I suggest you get all your evidence together to determine whether parenting time can be done safely. It may be that the old order is put in place. It may be that the parenting time may be limited. But Mr. Tipke, next time, please file the appropriate paperwork with the court so that you get justifiable reason to stop parenting time. Not just stopping it on your own.
Until then, am I allowed to still get my every other weekends?
I don't know, because I don't know how safe your house is if there was domestic violence the night before this incident and what's going on.
So it doesn't matter that she was in the vehicle with him when he tried to run her off the road?
I've got a lot of hearsay in this and a lot of stuff that you're throwing at me that I'm going to let the front of the court vet this out. You may file for appropriate parenting time show causes, Mr. Tipke, so that you understand you could be held in contempt of court for not following the court order without an order that says you can suspend parenting time. And that can be vetted out through the front of the court. They have a department that does that. That also would be able to, then you could explain your reasons, but you may want CPS backup on that because you can't just jump to your own conclusions here.
That's why I didn't.
I am not sure. I am not
outright accuse him. I was waiting for a mandated reporter to report it, but evidently they ain't doing their jobs either.
Well,
because there was nothing to report, sir.
And that's what the medical reports and all that are going to need to be turned into the front of the court. Any issues of domestic violence? Was your current significant other arrested, Ms. Sumner?
He was arrested, but I really just wanted him to leave. I didn't realize that they would arrest him, but there is no charge. There was no conviction.
Is he
still was released the next day. Yep.
Is he
still live together?
Great. Okay. Alrighty. So I'm not changing the prior order, Mr. Tipke. I won't change anything at this point. I don't have enough information to do anything other than send this to the front of the court to let you guys both vet out what should be done appropriately in the future. All right?
All right.
Good luck.
All right. Thank you.
There is no good answer there.
Oh.
And the young lady is probably more mortified than anything. The court's reviewed the motion. I did contact the front of the court to make sure that all other issues that needed to be dealt with were dealt with here. So forgive me, I just thought it, because some of the information like, are you on state aid, is not in the file. Are there any arrearages? Not in the file. Have you had any parenting time problems in the past year? Not in the file and not in your motion. Those are three of the things that have to be nullified before I can grant your motion. They confirm that it's good to go. So your motion's granted.
Appreciate it. Thank you.
No problem. Sorry, I jumped through the hoops for you. That way we didn't have to delay.
Yeah. So we're all set with the exemption for front of the court?
Yep. Well, it's going to go through. I mean, it'd take a few days to process.
Okay.
Yeah, I take it you guys are both working kind of in agreement with how you want to bring the divorce to a conclusion.
Yeah, it's amicable. And on the finance part, we're going through mediation, but we're both amicable there too.
Okay. I'll try and get set up a settlement conference in January after the 6 month is, because there's a 6 month waiting period. Once that 6 months elapse, which will be on January 5th.
Yeah.
I'll bring in sometime soon after that for a settlement conference. You got your paperwork. Where at? You bought it from the Legal Assistance Center, correct?
Correct. Yeah.
All right. So in that packet is a judgment of divorce.
Okay.
All right. So we'll need that judgment of divorce, and I will need a uniform child support order like you just did, except it's going to say final on it. Oh, this one does say final. All right. Just copy this one and attach it to the judgment. So there will be a second one. That way we got a full packet of it's finalized. But yeah, I'm going to put this order in place. Technically, it's a temporary order because your case isn't final yet.
Right.
Okay.
But just, yeah, you've got the copies of it. So we'll just enter that all in again. All right. So your motion's granted. See you in January.
Okay. Appreciate it. Thank you.
No problem.
Care. Bye.
2966DS. I believe that this is Ms. Perry, this is your motion.
Yes, sir.
Mr. Block, please proceed.
Thank you. There's two motions in front of Your Honor today. Instead, I'm not going to go through all of the.
One is set for 8:30 for August 30th. If I can, let's get them both done. That way, I don't want to take up any more time parties than necessary.
Yeah.
All righty.
The primary thing that we're here on today, to cut to the chase. My client has primary physical custody of the child who is age 5.
Correct.
The father, defendant, has summer break with the child from 1 week from when school releases, and is to return the child 2 weeks before school starts. School started August 2nd. He has not returned the child. Mother came up here in July 30th to get the daughter. Defendant refused to return her at that point, and now we're at August 16th. He still has daughter and is refusing to return her. So the primary focus of today, mother flew up here again from Texas to get the child, to get her enrolled in school, which started about I don't know, 2 weeks ago, I guess, at this point.
Mother also caused some problems at the father's house.
Well, yeah, and I don't want to say too much about that because there is,
there's pending charges, I assume.
Exactly. She drove by and was hoping to pick the child up, and apparently things did not go so well, and I'll just leave it at that.
They did not go well at all. So she has charges pending.
That is correct.
But Mr. Merrill, I need to hear from you. This child, you're under a court order right now. That child needs to be turned over today. You're in violation of a current court order, Mr. Merrill.
Yeah, so the pickup instructions weren't followed, and then it, in my opinion, became unsafe to meet up with her. And so that's
at this point in time, you need to comply with that court order.
Yeah, I mean, I don't have a problem with complying with it. I'm just explaining to you why we got here.
Yeah, I understand. We got here because you guys can't communicate worth heck. So I suggest you get the communication because I'm enforcing the current court order. But if you continue to withhold the child, it can suspend all of your parenting time into the future. And understand, the longer you hold this child, the more likely that she could file a police report on you for parental kidnapping. So you're both kind of in violation here. She's in violation because of your actions in trying to pick up the child, which may be utilized as a defense in the case that's pending. And right now, you don't have a defense in turning the child over. The child was supposed to be turned over already.
Judge Bryant laid out specific instructions on us to me. She didn't notify me that she
Well, this
was
child
talking
is
to
not
me.
in school and has missed 2 weeks of school because of your decisions.
Well, those are.
Let's arrange a pickup at a police station, I would assume. Would
Police
probably be a
I
good.
don't have a problem with it. We were supposed to meet at the airport. She never had any intentions of meeting up at the airport. She showed up at my house
Okay.
unannounced.
Well,
She has not agreed
the
to meet at the
child
airport.
the child is with you. Let's
Yeah.
get the child turned over to the mother now. The question is time and place. Let's make one for today. And then I suggest you
meet her at the
follow the
police
orders
station.
for the future. You would what, sir?
I would only meet her at the police station.
Then let's find a police station to meet at.
And noon today? Does that work for you,
Noon.
Mr. Merrill?
Yeah, that's fine.
Noon today at which police station?
Grand Rapids police station is where I would want to meet at.
That one doesn't have good parking. Might I suggest Kentwood or
That's true.
No, I want to go to the Grand Rapids police station.
Okay.
Everything is Grand Rapids. The court is right there. I stay in Grand Rapids. Everything is Grand Rapids, Michigan.
All right. Just go down to the Grand Rapids police station and pick up the child, ma'am. And sir, drop the child off.
are they going to go inside just to clarify? Because there's
I don't need to. As long as we're in front of the police station, there's cameras there, I'm fine.
Inside. Let's go
inside. Go inside. Go inside. That way the exchange can be completed.
And it can be recorded on presumably the police cameras.
Right.
Okay.
I was going to say
today,
that's why I'm saying inside, because they have cameras.
Yeah.
All right.
Noon today.
Noon today at the Grand Rapids Police Department.
Okay, that's motion one. Motion two was contempt of court. She has expended $2,600 coming up here on July.
And that motion is going to be denied because of her actions that led to police intervention that led to her arrest and the subsequent charges. I think had she have acted in a different manner, I might have done that. But with the actions that occurred, I can understand why he withheld a kid for a little while, but not for the 2 weeks, not knowing and standing on the fact that the order has not been complied with completely is not going to be a defense for him either. So no, I'm not holding him in contempt at this point in time because she's the one that broke into his house and created havoc and is now been arrested and is going to have to deal with the consequences of that crime. I'm putting both parties on notice that I'm not changing anything. The orders are going to stay the orders. I'm not changing custody. She already has custody. I'm leaving it just the way it was because neither one of these parties have been appropriate at times during this entire case. So, former orders stay in place that Judge Bryant put in place. Both of you comply with it. And if there's any problems with the communication in the future, let's find a different way of doing that. But you're also supposed to be using, I think, my Family Wizard app.
That is correct.
So any contempt charges are denied. Any changes of custody are denied. Continue with the current court order. Get that child exchanged at noon today and get that child in school on Monday, ma'am. All right.
Very good.
Okay. Have a good day, everybody. Take care.
Thank you.
Thank you. Good grief. 210DS. I will note that the objecting party here, Nathaniel Phillips, is not present. This matter was set for hearing at 9:30. It's now 10:04. Ma'am, you are here. You did not object to the front of the court recommendation. As he is not here on his objection, I'm withdrawing the objection and the front of the court recommendation will enter.
Please, because I don't agree with what he just did. So, yes, please.
No problem. Well, if he'd have showed up, normally we go to a trial.
Okay.
We have a hearing on this. And at this point, he's not here to tell me exactly why. His objection is a little bit loose-ended, but it's still an objection. But since he's not here on his motion to object, I'm withdrawing it, and FOC recommendation will enter. Have a good morning.
You too. Thank you.
All right.
Bye.
64 DC. Mr. Scazzeri, this is your motion.
Thank you, Your Honor. Your Honor, we're asking the court to enter a temporary order for parenting time. Essentially, what's happening now is that the opposing party here is using my client's previous medical issues that she's having. She does need a liver transplant, and he is using that as a reason to deny my client parenting time. Right now, my client has not seen the minor child or had him overnight since June 28th, Your Honor. And it's become readily apparent that the opposing party will not exchange the minor child for an overnight parenting time unless a temporary order is entered. So we're asking that the court do that. We just rely on what we said in our motion.
And it's my understanding that we had a trial scheduled for next week, correct?
We did, and unfortunately, we have to adjourn that, Your Honor. My client does need to be in Detroit.
I understand that she's going to undergo some medical procedures.
Yes.
So obviously, we're adjourning. I was hoping to deal with this issue next Wednesday, but things have changed. Ms. Van Dyken, input, please.
Your Honor, the court will recall we had a status conference on this case a few weeks ago. At that status conference, we came to some agreements about implementing the parenting time. And I asked for an order from Mr. Scozzari. I asked for an order, then he sends me an order that doesn't comport with what we agreed to in the status conference. I simply crossed off what he put in there about makeup time. We didn't agree to that. And I asked him to enter the order. And then after I sent him the order, with that paragraph crossed off, I sent him emails. Have you entered the order? Where's the order? Where's the order? My client wants an order because this has been the problem. Hang on. We also requested her medical information. We have not gotten that yet. We would like proof of this appointment next week because this case has been adjourned no less than 5 times. This has been going on for over a year. So every time something comes up, she's got a medical appointment. She's got this going on. She's hospitalized. She needs a liver transplant. I need to see proof of this.
And again, we're doing it because we've based everything on the fact that she's got some medical issues that need to be dealt with because of her past background. Mr. Scozzari, is there an order floating around that has parenting time on it?
There is, Your Honor, but the primary issue here is that my client is deserving of makeup parenting time. I mean,
and we can argue that at a later date. Let's get the order in and get some parenting time going for her now.
Certainly.
What I would say is go ahead and reserve an issue of makeup parenting time for the trial, and it may or may not be granted. The idea is let's not glut this up when there's a parenting time agreement that could be put in place, and then she could start seeing this kid.
That's fine. And Your Honor, I just want to add, I did just email Ms. Van Dyken proof of my client's.
Good.
These parties are also supposed to be using a backtrack device because of the history.
Yes.
And I have not seen Ms. Evans' backtrack usage.
I haven't seen Mr. Nowicki's either, so I think
I've sent him to you.
Exchange that, please. What I don't want to have happen is that something unfortunate happens with Miss Evans' medical treatment, and this kid goes without knowing a mother at all. I'm assuming your client still is on the waiting list for the transplant, sir?
Yes, Your Honor.
Okay, and it's got to be a complete transplant, not a partial?
I think Miss Evans can probably speak to that a little better than I can.
Yes, Miss Evans.
As of right now, we had lab work done yesterday, and in every single medical blood lab work, they do a complete metabolical panel, including alcohol. They did that when I was hospitalized, right when they got me, throughout the entire time. I have another appointment today that has an alcohol panel on it as well. Backtrack does not work for me because I am on multiple prescriptions that make it go off. And I can show proof of all of my medication as well.
Well, if it goes off, then we need to know what the medications are that are
right. And that's why they said, and
because
I
obviously,
agree with that.
Obviously, medications going off is going to be fine.
Right.
Yeah,
and
they're looking for a very specific thing that you've been using in the past that will show up as a different part of that.
Right. And Backtrack has asked me to ask my legal representation to find an alternative to Backtrack because of that purpose.
I think what my client is trying to say is that, based on the fact that she needs this liver transplant, she's having obviously in order for her to hang on, Aaron, in order for her to get that transplant, she has to show that she's alcohol free, right?
Right.
So I think, I'm happy to provide Miss Van Dyken any backtracks that I do have.
Please do. And if those backtracks show that she's using the medications appropriately, that's what it should show. But continue to use backtrack until you can find a differing. Let's see if we can get. Is there something out
it's
there?
It's going to go off every time I take it, though.
Yeah. And so I think
if it goes off, as long as it doesn't show alcohol, you're fine.
It shows it with the prescriptions. Is what I'm trying to say. That Backtrack has agreed to that.
Right. Okay. As long as it's not showing alcohol, you're fine.
Okay.
Right.
I think
but if you could find something else that may be agreeable between the attorneys, that would not.
I think that would be a blood panel, but
I think we can show the blood panels and all the other stuff because obviously that's happening regularly now that she's on this transplant.
I'd be happy to have Miss Evans do a hair follicle, but I'm unsure if that would.
I don't think it would show it.
A hair follicle does go back. I just did one this morning with Judge Gottlieb. It goes back 90 days.
But it goes back 90 days. Does it do so on alcohol as well?
It does. It does.
Really? Okay.
Yep. I'm happy to have her do one of those.
Okay.
I would be happy
well,
to.
yeah, go ahead.
Okay.
Go ahead.
And I can send over my panel from today as well if you just want those.
Please, more information is better.
Yeah.
All right.
Perfect.
We want to make sure that the child's going to be safe with you. That's all that's been a concern. And we understand your medical issues, but there are some concerns here, and we need to make sure that parenting time can occur, but done safely. That's why all these safeguards have been put in place, ma'am. So follow through with them. Mr. Scozzari, strike the portion that says make up parenting time.
I can do that.
If you want to enter a separate order that says make up parenting time is allowed to be argued as part of the issue at trial, great. At this point in time, I'm not sure what makeup could be done because of the issues that are underlying this case.
And we'd probably need testimony on that, so that's fine.
Oh, well, you would, and whether it would be granted or not, it's a whole other question. Like I said, there are some issues in this case that have been ongoing for months. So since we have to delay the trial again, we'll get with you for a new date, get that order entered and follow it. Since we have one out there.
We can do that.
Okay, so will I be able to receive my child this weekend?
Is that what the order? I don't know what the order says. So that was going to be my when I interrupted Miss Van Dyken before she started to talk. My only question was going to be, could somebody have attached the proposed order? I don't have it. So, but
we can do that.
If you email it to me, I'll be more than happy to sign it this afternoon.
Okay, Stacy, we can just work off of the one we had. I'll strike that make up parenting time provision,
and I'll send you the information about a hair follicle, where to take it.
Okay.
Perfect.
All righty. Good luck to everybody. Ma'am, good luck with your medical. And sir, thanks for taking care of the kid.
Thank you.
Good morning, everybody. Take
Thank
care
you.
of yourselves. All righty. Good luck. Stay safe. Hey, do we have Miss Van Dyken's other motion here? I've read your motion, sir, and I read Miss Van Dyken's response. And if I read Miss Van Dyken's response correctly, ma'am, you're saying to go ahead and go to the parenting time that's listed in the judgment without supervision, right?
Correct. If he can prove that he's been sober in July and August.
Okay. Any ability to do so, Mr. Holt?
Yeah, Judge. Yesterday, my client went and took what's called a PATH test. I don't know, Stacey, are you familiar with the PATH test? Yeah, okay. I'm expecting that result within the next 5 days. Okay. So maybe
will that be acceptable, Miss Van Dyken?
That will, Your Honor. Okay,
then once you get that result, let's put in place the unsupervised parenting time from the judgment. As basically that's what you're requesting, Mr. Holt, right? Is unsupervised.
Actually, it was a bit more than that. See, right now he doesn't have even standard parenting time.
Yes, I understand that.
So what we're requesting is just the FOC standard parenting time for Kent County. Nothing more. We're not asking for a change in custody or even shared custodial situation. Just what's available.
As far as I know, the parenting time right now comports with friend of the court. The only difference is there's no holidays in here.
No holidays or vacation times like the spring breaks or the summer breaks.
Right. And Miss Van Dyken, any comment about summers? And how old is this child?
There's 2 of them. And Jacob, how old are they again? Oh, we can't hear you, Jacob. We don't know.
Yeah, good.
Maybe
Veronica? Miss Plune, how old are the kids?
The kids are 4 and 7. You're
okay. Ever since they took away birthdays off of all these documents and the judgment of divorce just lists TJP and AJP, I have no idea if I'm dealing with young ladies, young men, or how old they are. So
yeah, they're 2 little boys.
Well, we're going to start with getting the parenting time started, Mr. Holt, and then what I'll do is, if everything goes well, Miss Van Dyken and you and I can meet in maybe 4 months and discuss the holidays and summers and stuff. Let's make sure it goes well first and that he stays sober.
Okay, so that's one of my client's concern is, will he stay sober? I'm wondering if
that's why I'm delaying
just as I did in the last case, ask for a backtrack that during his parenting time, he blow at random occasions when Miss Plume texts him so we can ensure his sobriety when he has the kids.
Mr. Holt?
Yeah, I mean, look, my client is not opposed to continuing to prove his sobriety. What I don't want is there to be it to be a willy-nilly type situation and something that's going to be extremely costly. I mean, he's willing to go get these PET tests.
Okay, how much is this backtrack?
Like $129.
For
a
how
month
long?
Or
no, you buy the backtrack and you blow in it, and it sends a message to the opposing party like he blew at 9:45 and he was clean.
Okay.
So is that a monthly expense or is it a one-time charge for the device?
Expense.
One-time expense, and both parties. Well, I'd have him pay like 75% of it and her pay 25% of it. And that sounds like it's a reasonable solution. I will not have him do it forever, but at least 6 months and we'll discuss it. But let's see how this parenting time goes unsupervised. And if he stays sober, we're going to talk about holidays and stuff in about 4 months or so. Now, what about holidays, Ms. Van Dyken? I think you said in your motion that you would agree with front of the court.
With our typical Kent County front of the court recommendation.
Yeah, of course. Then we get the
so
holidays.
The only thing that we're not addressing right now is just the vacation time, the summer parenting time.
Right. I'm not willing to jump to let's give weeks at a time when he's just now starting every other weekend and an evening during the week. And
but we can address that in about 4 months.
Yeah, we can address that in the 4 months because I want to see. Let's make sure he stays sober, and let's see how this goes unsupervised. And if things are going well. Again, standard is standard. We normally give parties, each of them, time during the summer so they can take these kids on vacation. Far be it from me to stop any kid from going to Disney World. So, I've got 3 weeks, Ms. Van Dyken, before.
I figured it. I was going to say kid or adult to go to Disney World.
I still haven't figured out what my Halloween costume is yet, but Mr. Holt,
coming fast.
Yes, Mr. Holt, you have the front of the court parenting time, holiday time situation?
Yeah, I do.
Okay. Yeah. And again, if everything's going well, the intent will be to look at summers and extended vacations like half of Christmas and all that. All righty?
Okay.
So as long as things are going well, it's not, we have younger kids here, they're not teenagers. I'd have less concern about teenagers, but we've got kids that are kind of at the mercy of who their parent is when they're under their care and custody. And I've looked at the past here, and I'm congratulate you, sir, on doing as well as you've done. It looks like you've jumped through all the hoops, and hopefully it stays that way. But thank you for working so hard. And I think from what I read, the only reason you're working hard is because of these kids. So that says a lot about you. And Ms. Ploon, you're doing well by allowing things to happen as they should. So let's get this started. We'll meet in 4 months and figure out how to proceed and how to advance it. Okay?
I do have
Sorry,
go ahead, Eric.
Oh, so Jacob, did you want to say something?
Yeah, I just had a real quick question on, okay, so we get the PET test back, should be early next week. What is the process from there? Because
the process is if as long as that test comes back and it shows that you've been sober, then we're going to go to unsupervised parenting time starting after you do the test.
Wonderful.
After we get the
When
results.
does the backtrack start that if it's being unsupervised?
I'm going to let the attorneys deal with that because they have more information about that than I do. I'm just now learning about backtrack. So
it can be ordered on Amazon overnight. So we can
cool. Even of course anything
Amazon Prime.
Anything can be ordered on Amazon and get here the next day. My wife ordered something and it was here 3 hours later. I'm like, what the?
Yeah.
I have never ordered anything on Amazon. I am not the tech person here. So in any event, yes, Mr. Holt.
I apologize. I just have
no need to apologize. What?
One more quick question. I guess maybe
Certainly.
A little bit of a clarification is as far as the backtrack goes. I'm willing to do that or something like that. We can discuss that, I guess. Happy to do it, but as Eric mentioned, as far as the willy-nilly, hey, can you
that's the point of it, is to call in the middle of your parenting time and say, can you blow, so that I know the kids are safe.
And I'm okay with that, but if it happens,
but I want to limit it. It should not be more than let's see, you'll have the weekend.
Correct.
So no more than 2 times during a weekend of your parenting time, and not at 3 a.m.
Yeah, right.
Normal waking hours would be acceptable, but that way it keeps it keeps her proof that you're not drinking on the side, which is a concern. Okay, and the willy-nilliness of it is kind of necessary because if you know it's going to be at 4 o'clock on Friday, you blow clean 4 o'clock and 4:15, pour yourself a scotch.
Sure.
So, okay.
Sure. No, and to be clear, I'm okay with it being random, but if it was
I don't want any more than twice during a 3-day weekend.
Yeah.
So choose your times wisely, Miss Ploon. All righty.
So
and this is going to be recorded.
Yeah.
I'm gonna. I want to, since I'm going to be asked to prepare a proposed judgment here. I'd like to go over it what I understand and make sure everybody's
Well,
under the same.
it's already in the judgment of divorce, so that's what we're following for now.
Oh,
And you're adding the holiday parenting time from front of it.
And I'm adding the backtrack, and I'm adding the number of times that they can be tested and so forth like that. So just to clarify, Stacy, correct me if I'm wrong. We're going to do this backtrack. 75% of the cost of that backtrack is going to be my client's responsibility. The 25% is going to be your client's responsibility. Upon receipt of a negative pleth test, which I will hand over when we get it, he will then start receiving unsupervised parenting time as per the judgment of divorce. The backtrack can be required to be used up to 2 times per 3-day weekend, and only requested during normal waking hours, not in the middle of the night or something like that.
Right.
And we're going to keep this process going for 4 months, and we're going to review at the end of 4 months as to whether or not there should also be vacation, like summertime and spring break and Christmas break, added to the parenting time. But right now, we're upon a successful pleth test. He's not only going to get his standard parenting time as per the judgment, but he's also going to get the standard FOC holiday time.
Correct.
Okay. All right. I can put that all in order. Stacy, was that your understanding of the agreement or the order?
What are you shaking your head about, Veronica?
I understood. So even if the test comes back, he's just getting unsupervised weekends and that evening during the week until 4-month review, and then the holidays. And
No, the holidays should start. The holidays go ahead and start now. The holidays start now.
Oh, so he's going to
after we're going to be talking about will be Thanksgiving.
Yeah.
Extended. I'm just really nervous for the kids.
I understand. A lot of holidays and most of them are spent with family, not just alone. So that's part of why the holidays are so important, because they should meet get some time with their grandparents and their cousins.
We've been splitting like Thanksgiving and Christmas and stuff already, even though it's not
okay. So alrighty. So
agree
that's kind of being done anyway. So alrighty, perfect.
I do have one other thing I just wanted to mention. In the judgment of divorce, if we are going by that, there's a couple things here. So number one is that it mentions the smartwatches that the kids are wearing. That's been a major distraction, and actually they're FaceTiming Veronica and her dad and other people while they're here. I don't see a need for those now. The boys are more than welcome.
No. That part of the order is going to stay in place. But Miss Plune, if you could talk to the kids about not doing it all the time, please.
Yes.
It shouldn't.
It's the FaceTime ID. It's brand new. They just got it.
So they're playing with it.
Yes.
See what you could do about limiting it on his time. I'm like, no offense, but typically my statement is your parenting time stops at his doorstep and his parenting time stops at your doorstep.
Right. So then he doesn't need to do the evening phone calls, because he calls them every night and I have to answer.
And that's why I am not going to, normally I would say that, but you're also getting involved in his life because of the tests for blood alcohol, and the kids' watches are going to be there. So I'm not removing that as a requirement. That maintains. Okay.
So understood. I don't necessarily have an issue with them. The clarification, I guess, is the fact that there's GPS tracking on it all the time, and I don't have anything to hide. But it's really just kind of, and maybe
I just said, Mr. Plune, I just said I'm not changing it. It's staying in. It's staying in.
And I'm okay with that. I just, on record, I'm not okay with the GPS tracking. I think it's silly. And regarding evening phone calls, I call Veronica's phone. I don't call Theo's watch. I mean, I don't make it a habit to inconvenience them. And that's a conversation.
You call Theo's watch when I don't pick up right away. And then when he doesn't pick up his watch, you call me right back with text messages.
And this is why I'm cutting this right now. We're done. I've issued the order. I'm not going to get into a tit for tat on this.
Okay.
All right. I'll prepare that proposed order and submit it.
Have a good morning. Thank you.
Thank you very much.
Ms. Van Dyken, I think that's the last one with you this morning. Okay, with me anyway. Have a good one. Thank you for being here, everybody.
It's Friday.
It's Friday.
Oh, God.
It's definitely Friday.
Okay, we can do Weiser versus Henkin.
I don't feel any wiser. All right, that one slipped. Sorry. This had initially been, this is plaintiff's motion. Ms. Camfield, is there anything she wants to add to it?
Your Honor, just that I know that in the response there was an allegation that the defendant only discovered this through a friend of the court investigation. That's not correct. My understanding after speaking with my client was that she informed Mr. Henkin of the fact that she was moving to Allegan. He was in agreement with that, and then all of a sudden
that's months ago. It doesn't matter.
Correct. Well, and then all of a sudden took it upon himself to enroll the child in Grand Rapids schools without her consent and knowledge.
Was that where the kids were before?
Ms. Weiser, is that where the child was attending?
He was attending Brookwood under my previous Kentwood address.
Okay. And when you're saying Grand Rapids, are we talking Brookwood?
It's Kentwood. But yes.
Okay. Because the children stay where they're at. You've got a trial coming up on September. No, not September 9th. You have a trial coming up. That trial date's not going to change. The reason that you're here is because since under the law, under Lombardo versus Lombardo, I can't change where the kid goes to school until there's a hearing. So the only reason you're here is for me to determine, do you need a court order that allows for that child to stay in the school where the child was? I know there is one from last March, but do you need a new one?
Well, I guess if that's going to be the court's decision until the date of trial.
That's not the choice the court has. That is the law. I mean,
I understand. I'm asking that this issue be reserved for the trial date.
That's what I'm doing. And the other reason that I'm doing this is because there was a request to go ahead and adjourn this until the hearing. But since I've had that happen to me prior, and then everybody turns in their trial briefs and all the exhibits and stuff, and the motion is underneath everything, and then you walk in and you look at the judge and go, so what's your ruling on the motion? And the judge is going, what motion? So we're here to make it official that this will be part of the trial. Do we need an order to keep the kid in school, or are they willing to accept the judge's order from last March?
I believe they accepted judge's order from last March. He's enrolled at Brookwood. I would like to put my objection as to service on the record, Your Honor.
Okay.
The plaintiff served the defendant directly, listed me as his attorney, and did not serve me directly, so there was no proper service.
There is no proper service, but since I'm not doing anything, I'm just offering the help of the court. That's why you're here. I'll note that as well. Miss Hinken, I'm sorry, Miss Weiser, you really need to serve the attorney if there's an attorney. I know you're not an attorney, but you're held to the same standards as an attorney if you file your own. Miss Campfield can now help you with that. I'm sure that mistake won't be made. And I have no doubt that Ms. Campfield probably would have advised you on the law and told you this motion could be considered frivolous. It's only not frivolous in the fact that I was willing to say I'll issue another order if you need one, because I want the child to stay as stable as possible. That's what the law says. That's what the law demands until there is a full hearing. So I wish you well. It's my understanding that the September 9th hearing is not being adjourned.
All right.
So we're going against.
Any other questions, Ms. Campfield, Ms. Lopez?
No, I'll be obtaining a prior record of the file from prior counsel.
No problem. Well, the court's file is pretty thin, so it's not that thick. So
I did have a question.
Yes, sir.
Yeah.
So for pickup and drop off, is there a way, because right now it's 6 o'clock on Mondays and Fridays, is there a way that we could do pickup and drop off after school when school starts like we used to, since she works in Grand Rapids? And
I will let your attorneys discuss that. That issue is not before the court.
Okay.
Yeah.
All right. The attorneys may discuss that, but we want to make this as easy as possible for both of you.
Right.
So whatever's easiest should be easiest. And if let the attorneys discuss that, and they may be getting into negotiations on how to settle the trial too. You never know. All right. Good luck, everybody.
Thank you. Bye.
Ms. Weiser, I'll call you.
Okay, thank you.
All right. Bye-bye.
All righty. Good luck, everybody. Next.
I have Tracy Brower here.
I think they killed a tree on this one.
I agree with you.
How's everybody
Good
today?
morning. Good, good. Welcome to all of you. Thank you for all of the reading. What, over 500 pages? And Ms. Coletti, I got your response and I went through it anyway. I'm sorry. I wanted to get a flavor for what's going on. So I did read everything. It's confidential. So, and I am taking it with a grain of salt until the actual testimony can back up. So I just wanted to get a flavor for what's been going on, because these cases are awful, because we have a 16-year-old driving the bus regardless. Okay. So let's go on the record in the matter of Powers versus Powers. Ms. Jernigan, this is your motion. What do you care to add to it?
Thank you, Your Honor. Just that we don't have facilitative gatekeeping in this case. We did try mediation with Sean Perry and actually been to mediation, and my notes reflect 3 or 4 times. We've done our best to come with agreements. The last time in October that we attended, Randy Flood's report was discounted. there was no discussion on extending parenting time, and I sent a request to email to Deb in September of 23. And it was all focused on the child's college education, and we worked through all of that. But
is she a sophomore this year?
She'll be a junior.
Is she going to be a junior? Because I was wondering because of her age. I wasn't sure whether she'd be starting her sophomore year or her junior year. So we have 2 years left. She'll be in college and turn 18 soon after she starts college.
Correct.
Okay. All
and
right.
all requests for, in the spirit of our mediation agreement in March, if my client needed to try to reschedule some of his parenting time, which is limited anyway by agreement, mom was supposed to facilitate with that. And now the responses are the child doesn't want to, or you're punishing the child. And again, it just goes to, this is not facilitative, it's restrictive. And my client, and it's getting better. I mean, it's before she wasn't coming out of her room. Randy Plugg's report came out. She came out, and things were getting better. My client was very hopeful, and now we're back getting stuck again because the
I have a question for Miss Coletti. When your client has this child, how often does she stay in her room there?
Well, she's a very active child. She does dance. She does.
That was going to be my secondary question. I was asking where she's at. What does she do when she's home?
Well, she's mostly with friends. I mean, when she's home, she's in the house. But again, at Mr. Power's house, she's in the house. She's out of her room. She makes lunch for him.
All right. That's not the helpful answer. I was trying to find out how active she was in mom's house, because once my daughter turned 14, I only knew she was home when her bedroom door was closed. She's now about to turn 24, and the same thing happens. I see her as she goes by to the kitchen to get food from her basement bedroom up into the upstairs area to get food. Now this is all I get. This is the communication.
Exactly. Yeah.
That's what I was asking, is what does she do at her house? Because Mr. Powers, I'm trying to determine if this is just normal for the child, because that is a normal activity for 16-year-olds, is to say, I don't want to deal with you guys. You know, you're lucky to get a hug. God help you if you get one, and it's a side hug at best. But I'm just trying to determine if this is a normal behavior for the child in a home.
I'm going to give you an example. Labor Day, the child's going to go off with friends. That's what she.
That's what she does.
Yeah,
I know.
Definitely.
She's at the age where nobody sees her.
Yeah.
Now she does not have a boyfriend, correct?
No.
Not that you know of. No offense, sorry. Because that just adds a whole other layer to this.
I know.
But my thing is that if she can be in the bedroom at his house, and she's at a bedroom at your house, she can be at either bedroom. And the court under Luna versus Regnier does have to review parenting time if parenting time has been limited. So it might be appropriate to increase the time, and if she's in the bedroom, she's in the bedroom. And I can't help you with that one, Mr. Powers, because that's what a 16-year-old does. But she's also doesn't want to be trapped at your house either. So if her norm is to go out with friends, that's also appropriate to do on your time. So,
she's fully allowed to come and go.
Well, and she may not, sometimes, from what I've read, she may not feel comfortable asking. Is what I'm and I realize that, and you probably don't want to give up the time because your time is limited.
Very limited.
So at this point in time, folks, I think what we need to do is have a hearing.
Your Honor, before
yes.
we go there, don't forget the judgment of divorce says on page 5 that before a motion is filed, we have to have mediation. This is the second time he's filed a motion without going to mediation first.
Didn't you have mediation with
3 times?
Yeah.
And
it's not working. I'm done. We've got a 16-year-old in limited time.
If you look at the mediation agreements that we have, Mr. Powers was supposed to do joint counseling with Lila and contact Dr. Post. I subpoenaed his records of going to counseling with Dr. Post. He's not doing what he's supposed to do, and he's coming in saying, no, it doesn't matter.
Well, and I will reserve that for the hearing.
And that is just another, what we call the restrictive gatekeeping. And
that's my problem. My real problem here is I've got a 16-year-old and only 2 school seasons and a summer to deal with. After that, we're done.
Yeah.
So,
and
it's also been my experience this as well. If she doesn't get an established relationship with her father, once we're done, we're done. And I've had parents come back at the age of 18 and go, I need help with college. Can the other parent do that? And I'm like, the law does not allow for that. Either she has a relationship with her father and her father will be willing to help pay for college and move her or get furniture, or he won't, because there's no relationship. So
correct.
We need to do something, and I'm overriding that part right now because of reality.
Thank you.
I'm not going to have this drug out because mediation and then nobody agrees, and then mediation and nobody agrees. And next thing we know, the child's over 17 and I'm not going to do anything.
Okay, that's fine, but the problem is we did have an agreement for joint counseling. The only it's not because Randy Flood's report came out.
Well, and what I'm going to ask Ms. Jernigan is make sure that you are in compliance with that, because that will be part of the hearing. And if he's not in compliance, that hearing may be a very short hearing.
Your Honor, the agreement states that my client will reach out to Dr. Post and then they'll work to try to coordinate with Patricia Dykeman.
Hopefully he has.
He has. And
well,
so
counseling. It hasn't happened. He's supposed to have co-counseling with Lila.
He said they will talk about it and would be on Dad's parenting time. But the problem is by agreement, we don't even have a schedule in writing on his
the reason that I am doing this is because if I grant a hearing, somebody actually gets to talk with the child from the court. That's one of the 12 factors that I will have to consider, along with the 6 parenting time factors. The real question is going to be between the attorneys, and I'll let them discuss this, because you have to agree to my having the hearing. You can ask the judge to do it, and the judge can look at her docket and go, mine's full, I'm going to give it to you. And if this winds up being a multiple day trial, realize that with me, the judge's docket is a lot more open. So if you're going to do 2 or 3 days, you might get it done within a month. With me, it'll take 5. So that's part of what I wanted to put on the table, because I'm not going to have the attorneys choose right now. I have no dog in this fight. I am willing to hear it. But again, you guys have to agree to that with the understanding of what the consequences are. Otherwise, we will send it to the judge and have them set a trial date for you. Well, a hearing date. Trial's already been done.
Your Honor, so the court is not ordering a specific parenting time?
I'm ordering to comply with what the parenting time currently is, because there are counter arguments here, Ms. Jernigan. So I'm not changing anything on a Friday morning.
No, and I appreciate that, Your Honor. I'm just wanting to make sure how the order will read, because I anticipate having difficulty just getting an order entered after today's hearing. So I just want to be clear on what the court is ordering.
I'm ordering that parenting time continue as is, and we're ordering a hearing.
Thank you. I would request with the judge, Your Honor. No disrespect.
No, I don't take any. Like I said, I don't have a dog in this fight. And sometimes it is a matter of getting it done. Because with me, everybody comes in thinking they're getting it done in a day or two, and the next thing I know, I'm doing an 8-day trial, and it's taken 9 months. Because I have a 4-week rotating schedule that 18 departments control.
Are you going to refer to FOC for parenting time evaluation?
No, I'm doing that. We're going straight to a hearing.
Thank you.
I'm not going to waste everybody's time. Again, we've got a 16-year-old and limited time before she's 18.
Thank you.
So no, I'm not delaying this anymore. I'm cutting it off and saying it gets a hearing. Okay?
So I will draft the order, Your Honor. I'll bring it down this afternoon, and it will just state that, just to be clear, parenting time is per the status quo, and then Judge Bryant would set this for a hearing.
For a hearing, correct.
Thank you. I will draft such order.
All right, good luck. And that way Judge Bryant can talk with the 16-year-old and get her input.
Thank you.
For good or for ill. All right. And make sure, Miss Coletti, and that was going to be my first question was what she does in her house, but the other question was, what are the activities that she's all involved in? Because that's going to be necessary too, because, just because you guys are available doesn't mean she is. And she's 16, and the court's going to back up what she wants to do, because that's her persona at school.
And my client's more than willing to facilitate that.
Yeah. Right. All righty. Good luck to all of you. Any other questions?
Are you reserving attorney fees?
I will reserve attorney fees to the extent that if he has not complied and the hearing goes quickly south because he's not in compliance with previous orders, other than the mediation, then you may argue for that.
What about, Your Honor, about mom's non-compliance? Because there's also a mediation agreement where mom is supposed to be facilitated.
And I didn't say who I was reserving the attorney's fees for.
I would just request both.
I was just going to say both of you have the right to argue for attorney fees over frivolousness or non-compliance.
Okay, I will put
whether that goes any further, because I'm not sure what she's done and what she's not done. All right, and I'm not sure what he's done and what he's not done. Both of you are saying the other side's not in compliance. Make those arguments, but remember, the main argument's about parenting time.
Yes,
not about animosity.
Correct.
All righty.
Thank you, Your Honor.
Good luck, everybody.
Thank you.
And
thanks.
Part of me wants to say thank you, because the last time I dealt with a child like this, I almost put in my resignation. I wish I were kidding. I'm not. I dealt with it for 2 years, and it was the most frustrating thing in the world. So at least I'll try and keep my job now.
Okay.
Have a good afternoon, everybody. Good luck.
Thank you.